Benjamin Ngura. You're going to have to correct my pronunciation, Ngaru, who is the Senior Officer for the East African Center for Forced Migration and Displacement. Sat with me is Jacques Ejok, and we are going to be talking today about refugee law within Kenya and the ways in which EACFMD, their partners, and others in the refugee community are attempting to influence the refugee regime. We're very excited to have Benjamin here with us today. Benjamin is joining from Juba, South Sudan. Thank you very much for taking the time in your busy schedule, and we look forward to having you back in Nairobi tomorrow. I wonder if you can help us with our introductions just by letting us know a little bit more about yourself and what EACFM does and what you all have been up to in the past months.
Awesome. Thank you, Andreas, and good morning and good afternoon, everybody. My name is Benjamin Ngura. I'm the Associate Director at the East African Center for Forced Migration and Displacement. But essentially we are a firm that works across the silos, working with humanitarian actors, policymakers, academics, displaced persons, and others to sort of work across the humanitarian peace development sort of nexus and silos to influence displacement policies in this region. We have certain thematic areas of interest, for example, climate displacement, refugee inclusion, and access to financial services and labor markets, complementary pathways, as well as matters touching on SOGIASC. It's a pleasure to have all of you join us today, and I do look forward to this conversation.
Fantastic. Well, I'm going to remove myself from this seat, and I think your colleague Anne-Marie is going to swap in just a moment. But Benjamin, I wanted to begin by just asking a question about EACFMD as an organization, what you're doing to foreground refugee knowledge within the refugee legal regime in Kenya and East Africa more broadly. You know the work that RLOH does and the efforts that we've made to have an inclusive and refugee-centered knowledge production ecosystem. And I know that the sort of intention is much the same at EACFMD, which is part of our sort of foundation of the collaboration that we have between our organizations. So maybe if you could start off with that, and then I guess that will very easily liaise into introducing Anne-Marie, and Anne-Marie and Jacques can take the conversation with you from there.
Cool, thank you. I think it's one of those areas where I can just speak off the cuff. So the East African Center for Forced Migration and Displacement was established in 2019, and then with the background, myself and a few other colleagues who have worked over the benefit of working in various INGOs in this operation, beyond the region, in South Africa, the DRC, the whole of Southern Africa, the Libya situation, as well as Niger. And a few of us have met both in conferences and in schools, for example, at RFC, where we did benefit from the studies there and other institutions. And what we noticed was that there was a gap in terms of both A, the practice of forced migration, and two, the study of forced migration within the graduate level in universities, as well as at the undergraduate level. And so one of the things that we sought to do was capitalize on this space and work with policymakers, academics, and others, and NGOs, to try and see how we could influence policy. We had the benefit of going to the schools where in some instances you learn about refugee camps in Kenya, and it was quite unfortunate that when we were in the country we did not have that benefit of perhaps being exposed to international refugee law. And so when we did come back, one of the things that we did was to move beyond the usual NGO space, but also then focus on certain areas. So for example, policy was something that had been dragging for a while, and what we noticed was that notwithstanding the fact that this region and this country had been quite generous in welcoming displaced persons, and in going back to the 1994 situation in Rwanda, the Sahel situation in Somalia, the lost border situation in Sudan, back then as it was now it's South Sudan where I'm joining you from. What we noticed was that on one hand, the country had been welcoming displaced persons for the longest time, and on the other hand, the policies and the legislation had sort of lagged behind the practice. Very few persons have been practicing international refugee law before the courts, or even the study of forced migration in itself, whether it's international refugee law, or other fields of law, is barely sort of been taught or practiced. And so one of the things I started doing was working with actors across the silos. So whether it's NGOs, whether it's academic institutions like the RSC, and one of the benefits out of that was the refugee-led research hub sort of collaboration that we have between ourselves and yourselves. And I'm glad to see Andoni there and Anne-Marie in the background, because they are one of the first beneficiaries of this sort of collaboration. So one of the things that we needed to do was walk the talk and include refugees and other displaced persons within our ranks, but also within the governance structures of organizations. So there has been a lot of talk in terms of localization and the grant again right from the World Humanitarian Summit and going even beyond that. And what we did internally as an organization was not just speak in terms of including refugees and other displaced persons, but walk that talk and have displaced persons working with us and also being part of the governance structure. So within our board, we have several displaced persons who are members of our advisory board, and within the organization itself, we have displaced persons who work with us in different consultancies. And I'm glad that's why Jack is here, and we've been working together as part of the graduate research program that the RSC and the Refugee-Led Research Hub has been quite generous on. And these are the areas that we have sought to sort of expand access to labor markets for refugees and displaced persons. And I think it's something that we will come back to thereafter. Certain other areas that we perhaps work with is having a closer collaboration with local and regional and institutions below that. So in Kenya, we have been having a very close relationship with colleagues from the Strathmore Law School, who have been sort of working with us as we do certain consultancies. Beyond that, we have some good partnerships with the ACMS at the University of Leeds in South Africa, as well as the UCT in Cape Town, and other institutions. So one of the things that we noticed was that there was a need for collaborative effort, because if we were to improve the policies and the legislation in this country, then we needed the input from academia, we needed the input from practitioners, we needed the input from the humanitarian world, as well as development partners, to be able to work across silos and bring meaningful change, and not just working in the case or individual cases as has been in the past. I'll stop there because of time and then throw it back to you and Doris and Jack.
Yeah, thank you for that introduction, Benjamin. It's riveting, and I would love to be part of the conversation, but I'm going to do so from the audience. I know that you've got quite a bit on your agenda in terms of things that you'd like to talk about, including an extended discussion on law relating to the social economic rights under S28. So I'm going to turn to Jacques and Anne-Marie if you want to swap in for this position. I think it's only right as the two attachments between RSC, RLRH, and EACFMD that you can be in this conversation. So we've got about 45 minutes remaining, and very happy for the three of you to lead in the direction that's most sensible. Thank you.
Thank you very much, Andoni and Benjamin Garu. I'm honored to be the one to facilitate this session with my boss. I work under Benjamin and I've learned a lot from him. So Benjamin, you have talked so much about the refugee management situation across the East Africa, but I'm going to bring it closer home. I'm going to bring it to the circumstances of Kenya and the rapidly changing legal landscape, and going straight to the point. I will want to ask you, what do you think? We may not be able to exhaust exactly what the new law has brought, and we have seen so much enthusiasm from refugee-led organizations and other assisting organizations, and even the refugee community itself, but there's questions that still abound, and people want to hear from experts like yourself as to what the new law means for refugees exactly. So basically, can you take us through, maybe you can mention a few before we go one at a time, what the new law brings, what do you think is so important?
Cool. Thanks, Jack, and I think it's a pleasure as well to sort of have this armchair discussion with yourself, and I do acknowledge the great work that you've been doing as one of the researchers forwarded to us from the IRC, and I do see sort of great paths for yourself, whether it's within the fellowship or beyond, and I do look forward to watching. Before I sort of speak to those changes. I think it's only right to acknowledge that your presence here is an acknowledgement of the changes that we're witnessing as a result of the legislative changes in this country, having the new legislation enacted in late last year, that's in December 2021. Several key things sort of stand out, and we will come back to them down the road. But the one that is most passionate to me right now is financial inclusion of refugees and asylum seekers, as well as access to labor markets. And I think that falls within, I think, Section 28 of the new legislation. But beyond that, when you look at procedural things, whether it's within RSD and that's refugee status determination procedures, we anticipate great changes to come in, whether it's in terms of the creation of new offices, new office holders, new mandates, but also some, I think, substantive rights being given to persons seeking asylum, whether it's in terms of having a transit permit, whether it's in terms of access to legal representation, whether it's paid or whether it's free legal representation, but also the right of free movement, and beyond that, the right of refugees to sort of, or the acknowledgement in itself of refugees to enjoy the Bill of Rights, and I think, and Article 12 of the Constitution of Kenya, that's in Chapter 4. So I think, as we discuss, I will look forward to discussing how these changes have an impact on refugees and what changes to anticipate, but I'll primarily be focusing my attention on how it is able to change the inclusion in financial markets, but also access to labor markets in the country.
Okay, as a follow-up, as you said, and as Andoni had mentioned before, Section 28 of the Act is the enabler here. And so we would like to ask here, when it comes to financial inclusion, what specifically do you think has changed with respect to financial inclusion? Can you break it down so that at least people here can get to understand? Because there are fears that people still think, when you talk about financial inclusion, will people now have direct access to open bank accounts and M-Pesa accounts, and without having to require additional procedure before they can do that?
Thank you, Jack. Well, before I get into that substantive discussion of Section 28 and the financial inclusion, it's perhaps important to sort of take a step back and acknowledge the process that the country has gone through, and I think the operation has gone through prior to the enactment of the Refugees Act, I think 2021. There have been several hurdles, and I think some of the submissions that were put forward while in acknowledgement of the challenges that displaced persons were facing. As I alluded to earlier, refugees and asylum seekers have been warehoused for the longest period, and most of them had been denied freedom of movement, they had been encamped, there was no right to work, and then when you look at access to class and permits, the procedures were quite unclear, and they were quite cagey. And there have been several reports that have come out, for example, the CGDF report, that's the Center for Global Development report that was released late last year, entitled From Displacement to Development. I hear the IRC, through its refugees economies, has released several reports which have been based on fieldwork in this area. And certain areas have been repeated again and again and again. And I think these form parts of the discussion today. One of them is the need to remove legislative and policy barriers and enable refugees and support refugees in accessing to employment opportunities, but also hiring refugees and supporting refugee-owned businesses. I think the second thing that has come out quite clearly again and again and again is the need for refugee economic inclusion through direct hiring and supplying from refugee-owned businesses. And I think when you look at Section 8.2X of the Act, it sort of empowers the Refugee Commissioner to put in place measures where resources, whether it's in terms of goods or services, can be sourced locally, and I will touch on this down the road. The next thing is helping refugees sort of obtain Class M permits. As I indicated, one of the biggest challenges was, whereas the legislation in the past, I think the 2006 legislation, had in some way provided access to Class M permits, the process of acquiring these permits was not clear. The procedures and the requirements were also not quite clear, and those posed certain bureaucratic impediments to the realization of financial inclusion. And then this, I think, touches into other things, for example, documentation, permits to open up businesses, the ability of refugees to operate M-Pesa accounts, whereas as nationals we would sort of assume that that's an obvious thing. Research after research after research has been indicated. So, for example, whether it's from CGDEV, whether it's from refugees economy at the RNC, whether it's the the report that came out late last year, they've all alluded to the fact that the absence of refugees and asylum seekers from enjoying certain financial inclusion tools, such as M-Pesa, which has made life easier for everybody else, has sort of hindered their ability to be involved and engaged in financial inclusion. Finally, the last thing that I think I must acknowledge, certain partners have been doing some good work around this, is livelihood trainings and offering refugees apprenticeship and employment opportunities. And I think the ILO and the ILO prospects have been doing some really great work in this regards in terms of reskilling refugees and allowing them to gain some sort of skills and apprenticeship in the region. So having said that, allow me to then just go back to the Act itself, and Article 28 is a substantive legislation in this regards. So beyond the procedural changes expected in the Refugees Determination, the creation of new offices, as well as the right to legal counsel during RSD, a greater space for the enjoyment of socioeconomic rights will also be within the grasp of displaced persons. And as indicated, one of the biggest departures is the access to financial inclusion and labor markets, perhaps through subsidiary legislation that's being drafted right now by certain partners as well as the government authorities to operationalize the Act. And at this juncture, it's important to note that this has been a collaborative effort by different stakeholders through advocacy, through direct lobbying, submission of memoranda. When you look at part 5 of the new legislation, specifically section 58, when it comes to access to labor markets and financial inclusion, well, I will not belabor into reproducing that particular segment of the legislation here. The Act expressly acknowledges the right of all refugees to enjoy the provisions of the Bill of Rights under Chapter 4 of the Constitution. And these rights include the right to life, equality, freedom, human dignity, as well as freedom of movement under Article 39 of the Constitution. One of the most important things is that the Bill of Rights under the Constitution, it notes that these rights belong to each individual, including refugees and asylum seekers, as we saw previously in a High Court decision, which Jack, I'm very well aware that you're familiar with. That's petition number 393 of 2018, which touched on the right to higher education for displaced persons who had come from South Sudan and were attempting to sort of be admitted as advocates of the High Court of Kenya. And the reason why these rights are important is because these rights place an obligation on states, Kenya, for example, to ensure that they enjoy those rights, and then refugees have access that's not impeded in the realization of these rights. But it also further obligates the courts and tribunals to implement these rights, or to interpret these rights in a manner that promotes values and that underlie the open and democratic society, which is based on human dignity, equality, equity, and freedom. It's therefore expected that any matters that will come before the courts trying to interpret the new Act, as well as looking at the Bill of Rights, which has now been sort of expressly acknowledged under Section 28 as being one that refugees can enjoy expressly. It will be interesting to watch how courts will interpret these freedoms in a manner that relates to issues, for example, encampment. I know as we speak right now, we still have refugees and asylum seekers still housed in the camps, but I think we expect or anticipate policy changes or legislative changes to come through under subsidiary legislation, or indeed as matters brought before the bench in this country. And I suspect that the courts will follow the precedents that have been set elsewhere, for example, in South Africa and other jurisdictions such as Ethiopia, Uganda, Peru, and Colombia. And the reason why these freedoms are important is because they are crucial to the realization of financial inclusion. The legislation in itself right now expressly acknowledges the role of displaced persons in contributing to the socio-economic fabric of the society. Indeed, it imposes an obligation on both the national and the devolved governments, as well as national governments and county governments, to go beyond the 2006 legislation and tackle some of the challenges that I alluded to before, such as permits and documentation. And an obligation has now been imposed on national and devolved governments to issue permits and other documents to displaced persons who wish to engage in gainful employment or an enterprise, or to practice a profession or trade where the whole qualifications as recognized. And as Jack yourself, you are a qualified person to practice law after now having done your KSL and then done your exams. And I'm sure you'll be one of the beneficiaries, if not of this particular provision. I think I must acknowledge the recent article that you did put yourself out, indicating how the new legislation has directly influenced your lived experience in this regard. And these legislative changes we anticipate will be able to then, over time, be able to enable refugees, whether it's in a group as a refugee-led organization or individually as yourself, to then apply and get permits from the county governments or national governments to then run businesses, to be able to supply goods to the national government and the county governments, or indeed, as we have seen in Section 12 of the Act, to be able to then supply goods within the refugee camps as a business and then improve their livelihoods and their daily lives. Allow me to stop there and then throw it back to you.
Thank you very much, Benjamin. And as you speak to Section 28, and the law says that at the very minimum, the refugee ID shall have the same status as the foreign certificate under Section 56(2) of the Kenya Citizenship and Immigration Act. And if you look at the Kenya Citizenship and Immigration Act, the foreign certificate, you can use it to actually apply for a driving license, an open bank account, and such things, as you have already mentioned before. There was such a huge debate here with some of my colleagues here. They were doubtful as to whether the regulation will actually limit the direct access to the labor market. I will give you only 1 minute to respond before I hear the reflections of Anne-Marie regarding this one. So do you think that this provision will give refugees direct access to the labor market, or do you think the regulation will actually have some limitation as to applying for work permit before one could be employed? Because if you remember, the repeal legislation prohibited engaging in gainful employment without obtaining a work permit first. 1 minute.
Thank you, Jack. And I'll be very quick and I'll indicate that at the very bare minimum, we anticipate the acknowledgement of Section 28(7), that the refugee ID shall have similar sort of rights as the ID for foreign nationals, to have sort of a similar footing, to be transformative. But we also provide an opportunity for refugees and asylum seekers to do all of the things that Kenyans and other non-Kenyans who are residents in this country can enjoy using their ID. So the very short answer is yes. Of course, there are certain qualifications that have been provided within the Act, but we do anticipate that Section 28(7) to be a game changer in terms of using their refugee IDs to open bank accounts, using refugee IDs to have M-Pesa accounts, using refugee IDs to access other socioeconomic services, whether provided by private actors or by national authorities in this country.
Yes, back to Anne-Marie, 1 minute. We really want to hear from our audience what question they have, because they are the ones who needs to hear.
Thank you, Ajak, for that wonderful conversation, and Benjamin for sharing your expertise on the legal framework. Mine is just to actually, I'm amazed with this new development, because I'm going to try to bring in the mental health part of it. You know how passionate I am about mental health. It has been part of our conversations, different conversations. And when we talk of refugees and people who have experienced migration, one of the reason and barrier to self-reliance is related to this lack of access to opportunities. So I'm seeing this development being really coming in to address and to give a chance to refugees to at least to have some peace of mind. Now mine is, I'm wondering right now, when can we start expecting the results of this amazing development? when can refugees expect? And also, how can we make it simplified so that the community can be aware of these new developments in the language that they can easily understand, that they can know they have some rights and how to access them? Thank you.
Yes, back to you, Benjamin. I know you're working on this already. You are working on 2 articles, of which I am assisting in both of them. So maybe you can just give a 2-minute reflection before I ask the last question, then we go take it to our audience.
Thank you to both of you. And I do acknowledge the very unique place that mental health and psychosocial support needs has amongst displaced persons in this country. And the ability of refugees to sort of access those services has in one way or the other been hindered by some of these challenges that we have noticed. In regards to the first question, when we anticipate refugees sort of start enjoying these benefits, I think the first thing that I would say is that this piece of legislation went through the legislative process, and in December last year received the presidential assent. So as we speak right now, this is an act of parliament, it's the law of the land, and therefore in law, refugees in theory ought to enjoy these benefits as we speak. However, we do acknowledge that sometimes policy then takes some sort of time to catch up to the legislation, or sometimes businesses, whether it's in private or public enterprise, does take time. So for example, one of the things that has been there in the past is non-recognition of refugee IDs, and Ajaki did raise Section 28(7) of the Act in terms of how do you recognize the value that a refugee ID holds? Can I open a bank account with it? So I anticipate that right now, if you walk into a bank, you will find a teller or a bank customer agent who will perhaps not be very aware in terms of what ID is this, right? So what value does it hold? Where is your Kenyan ID? Where is your passport? And so what I know that ourselves and other partners in this region are working, and that's closely linked to your second question, is how do we then simplify this legislation in terms of whether it's in terms of blogs, in terms of interviews, like for example the one Jack you did last week with the VOA News, or the ones that myself and yourself are working on as part of the CGDF program under the Let Them Work initiative, sort of simplify or sort of break down the Section 28 of the Act, and indeed other provisions of this legislation, together with the Bill of Rights, because as you will well note, the Section 28 affirms that refugees have the rights provided under the Bill of Rights of this country, and those rights include the right to life, right to movement, freedom of association, and so what we're trying to do right now is break down those pieces of legislation and policy into very small bits of information that we can then use as advocacy messaging. Of course, this will take time, but I know that next week we're also doing something along these lines. Ourselves and the Center for Global Development and Refugees International are bringing together private sector actors, whether it's in terms of banks, and I know Equity Bank has been doing some great work. The Safaricom Foundation and the Safaricom Academy has been doing some great work in enabling refugees and displaced persons access labor markets and financial inclusion, but to let them learn from each other and also learn from the developments of the law and legislation and policies in this country and in Peru, Colombia, and Jordan. And we're going to break down those provisions to understand. So what does Section 28 of the Act mean for me as a bank employee when a JAC comes to me and wants to open a bank account, or as a telecoms individual and a JAC comes to me and wants to have a SIM card, or wants to transact on M-Pesa, or essentially when a JAC comes to me and says I've qualified from the Kenya School of Law and I've been admitted to the Bar Association and I'm seeking gainful employment in my law firm. So I suspect that the last part will take time, but it requires a whole of society approach where we work with each other, work from the private sector, policymakers, sort of advocates for effective realization of these rights. It's not enough to have them in the legislation. The next step is to work with other partners to make sure that they understand what this means and they then respect these rights and afford displaced persons the opportunity to, whether it's open business, gain permits, get documentation or indeed have access to bank accounts.
Thank you very much. Benjamin, if I hear you right, you are saying the law is operative as of March, and that what has remained now is to actually push and lobby to give these service providers or the providers of financial products to actually change their internal policies and to allow refugees to actually access their products without any restrictions. The law came into force 90 days from date 17 of December when it was assented to by President, which was date 4 of March. And so anyone can enjoy those rights, but as Benjamin said, bureaucracy is another thing. So, and we need to work hard and also push for the change of internal policies from these service providers for the refugees to enjoy the full benefits. Enough of financial inclusion. I think we will hear the rest from the question session. Now about freedom of movement that is provided in the Act. The Act talk of two things. Number one is that there are designated areas in which refugees must stay, and then it also goes ahead to say that refugees have the right to move freely, that they can change their location, and it actually provide that if you are a refugee in the camp, you can actually apply to the commissioner to have your location to be changed, probably from the camp to the urban center, and through a formatted form that will be provided in the regulations. Do you think that one now is something that refugees can access, or dependent on the regulations? And I want you to be very brief on that, and also we'll put them together so that you answer us. One is about integration. The integration, the way the Act put integration, it says that there shall be shared facilities, institutions, and public services. So, but the way we know integration in the international arena and how it has been defined in the refugee governing statute is totally different from what the Act says. It doesn't talk about sharing of national resources. It doesn't talk about maybe access to certain basic services such as free primary education. So you believe there is possibly a long way to go with integration, and some scholars have actually said that it is a gradual process. So maybe you can satisfy us on those two things before we open up the question session. Thank you.
Thank you, Jack. And it's a very pertinent question, and I think that's why in the previous part of the discussion I did allude to the fact that we anticipate certain matters to be brought before the bench to have a determination as to what does this really mean. Because on one hand, we will note several things. So as you all recall, late last year in October, when Parliament for the first time did deliberate on the refugees bill as it then was, and we sent it to the President for his presidential assent. The document was then returned back to the National Assembly with a memorandum detailing certain amendments that the President did want included in the final version of the bill. And one of the very last pieces of amendments that have been recommended was the fact that there was need to give powers to the Commission of Refugees to be able to designate certain areas for refugees to be hosted, but also certain powers to be granted to the Commissioner to be able to relocate refugees from one area to the other. And this included refugees and asylum seekers who not only lived in the camps, but also those who lived outside camps. And I think that was within clause 31 of the bill. Now, if you look at part 6 of the Act as it is right now, it talks about designation of certain areas as areas to be control areas where refugees are hosted. Now, the reason why I did allude to the fact that we anticipate matters to be brought before the court and for the courts to interpret, and why it was important for courts to interpret the Bill of Rights in a manner that was consistent in a free and democratic society based on human dignity, equality, equity, was because on one hand, whereas the law acknowledges that refugees can access and indeed they should benefit from the Bill of Rights under Chapter 4 of our Constitution. And then if you note in Chapter 4, we have things like the freedom of movement in Article 39, as well as human dignity in Article 28. On one hand, the bill on now the Act talks about controlled areas and does not expressly do away with encampment. But on the other, acknowledges that refugees, certain restrictions and reservations that have been made by the country when it was then ratifying the 1951 Convention, that refugees do enjoy the rights enshrined in the Bill of Rights. And when you look at the Bill of Rights, it's saying every person has the right to X. So, for example, if it's human dignity, whether it's the freedom of movement, whether it's the freedom to engage in gainful employment, whether it's the right to life, the Bill of Rights does not say a refugee or a Kenyan. It does not say a national or a East African national. The Bill of Rights says every person. In an acknowledgement that these rights are not granted by the state, but that these rights belong to all persons, and an obligation does exist on the state to then ensure that all persons, including refugees, have access to these rights. Now, what I anticipate is that it will not be an automatic sort of enjoyment of these rights, but there will be some sort of contestation, and some of these matters will then go before the courts. And this is why the precedent, for example, petition number 393 of 2018 that I alluded to, or matters that have been adjudicated in precedents coming from South Africa, noting that our constitution has been heavily borrowed from the South African model, will come into play. Having said, I think one of the other things to watch out is that we anticipate subsidiary legislation to come into effect in the coming months, and I do know certain actors, some of them within and some of them outside of this forum, are engaged in that. And those subsidiary legislation will give us a clearer picture of the procedures, the requirements to enjoy some of these benefits, as well as some of these rights. But also the acceptance of the government of this country to then roll out CRRF is also another indicator of perhaps the trajectory that we're going on, but it will definitely take time. So allow me to stop there and then throw it back to you.
Thank you, Benjamin. I just want to reflect back on the issue of freedom of movement. Maybe in the position of a Kenyan who is opposed to this law, I would say that freedom of movement is a limited right under Article 24, and maybe refugees, if the Act actually limited them, they have no such right. And Alan actually spoke to this in a different forum, but because of time, we will really leave it here, and we get to answer the questions from our audience because they are the one who need to hear from us here. So thank you. Yes.
Thank you, Benjamin, for the update of the policies. Some of us never get an opportunity to read them. But my concern is we are talking about all these rights that refugees are supposed to be given access to. But my concern there is some of these rights that we are talking about right now, they used to be available to refugees before. So I'm curious to know what happened exactly in between there for those rights to be taken away. Examples like registration of a SIM card, or maybe even having an account with maybe with NTSA and having a driving license. Some of those basic things, they used to be available back then. But now most of those services, you can't access them with a refugee ID. So if you're talking about taking steps towards making things easier for refugees, for us on the ground, it feels like actually the government is continuing to limit us more and more. So I'm just curious, like what happened in between there for certain things to be taken away for us to be talking about them right now.
Thank you very much. Benjamin, I don't know if you're allow me to take that one. Okay, somewhere in 2009 and in 2013, the Proceeds of Crime and Anti-Money Laundering Act was implemented by the government of Kenya, and this act actually see refugees as terrorists, as people who are laundering money in the country, and that is where the limitation started. At some point before 2012, refugees could access these services, and if you remember, after the bombing of the Westgate Mall, so things changed drastically for refugees, and laws were passed to limit the access to certain services, and that is the beginning of the issues of refugees. So this is another turning point where Kenya is looking back and saying, actually, we need to change the restrictive laws that we had introduced after the 2013 incident. So basically that is what happened, and it is, if you want to see, it is section 45 of the Anti-Money Laundering Act. Maybe you can discuss it later. And also section 46, and that is where the limitation started, especially for financial institutions. But some institutions actually decided to bring in discriminatory laws, like we talk about Safaricom limiting refugees, and you know they do not fall under the category of such institutions which can actually refuse to register accounts with the refugees. So I think that is sufficient, and I have seen Okello, and yes, Okello.
Thank you very much, Benjamin and Ajak. So my question is very brief. Okay, right now we know that refugees are encamped in 3 different locations: Dadaab, Kakuma, and Durban refugees. And based on where they are, right now, they are given refugee identification card, alien card. But at a time when you have this alien card and you come to Nairobi, you cannot access resources. Maybe you want to apply for a job, and then what they look is, you are from, they come, maybe you are from Dadaab, and you will not be given this job though you are qualified. So the law used to be very, unfavorable for us or for those who are living in the camp, and very restrictive. So in this new law, is it still very restricted like that, or there is a bit improvement on it? Thank you.
Benjamin, would you like to take that?
I know you have extensively talked about this point, and I would not want to belabor so much on it. If I can throw it back to you, perhaps the only thing that I will say is that these things do take time, as I indicated before. We do not anticipate an immediate change. I mean, this legislation was gazetted in December last year, and we're now in mid-May, and we're still discussing how do we then simplify and operationalize this particular piece of legislation. Perhaps the second thing that I will say, that it's always interesting to see how the populace does then look at this piece of legislation and then take it forward, whether it's in terms of displaced persons of a constituency, or whether it's nationals of this country and residents of this country as another constituency. In terms of will a refugee then go ahead and say, I do have the right to open a bank account in accordance with the Act. I have gone to a certain bank X and have not been able to enjoy this right, and therefore I am trying to enforce my right to enjoy this particular benefit, or whether it's a business in this country that then says, oh, our legal department has advised us that we can employ refugees if they have a refugee ID under Section 28.7. The subsidiary legislation has come out, and our understanding, according to our advice from our legal counsel, is that enjoys a similar benefit as a Kenyan ID. And this person is qualified, and their qualifications have been recognized, and therefore they go ahead and exercise that right. So the interaction between those two constituencies and the powers that be is something that's always important to watch. The courts are always available for strategic litigation in case there are certain barriers that continue to exist. But the last thing that I will say is that it's important to always watch the nexus between displacement and humanitarian policies on one hand, and international politics on the other, and how those two interact to either restrict the asylum space or to build on that particular asylum space. And then I'll throw it back to you, Jack.
Yeah, thank you, Benjamin. That is basically close. That is it. And what I can add is that refugees have special circumstances, and there are certain requirements for every document that is issued, even the Kenyan ID. you are expected that wherever you are issued with this document must appear in the document. Is just like any Kenyan citizen here, maybe they can attest to it if there are some here. Maybe if you can be issued your ID in Kisumu, it must reflect that this ID was issued in Kisumu. So as to whether you are given your ID in Eldoret, Nairobi, Nakuru, or in Dadaab or in Kakuma, it is something that cannot change because of the new law. It will still remain so. But what we must remain cognizant of is the fact that the Kenyan public institutions hardly employ refugees. And maybe you have done a little bit of your research and you have found out that refugees are mostly employed by the private sector and the non-governmental organization and the community-based organizations. And these people are people who understand the circumstances of refugees. So, and now that the new law says that we will have access to public services and public institutions, we do not know whether that extends to actually employment rights for refugees within public institutions. Like, can a refugee maybe vie for an area MP? Is that something we don't know all those things? Or can there be an MCA within the refugee camp who can actually represent the voices of refugees in the county assemblies and in the national parliament? So those are some of the things that we are not clear yet in the act, and maybe the regulations will be the one that will clarify the position, and maybe going to court will actually do justice for us. So I hope that is sufficient. I think we can go to this side. Yes.
Minutes.
Okay.
Thank you, Ajak and Benjamin and Mary, for the very insightful discussion. What I want to ask is there has been points made about there will be contestations around the rights in which and ways which refugees will access these rights. When these contestations happen and there's need for strategic litigation, organizations such as yourselves will play a big role. But unfortunately, the high cost of legal costs and the resources that refugees have is very limited, and the ability to litigate each and every contestation seems unfeasible. Is there any way in which there could be precedents set when one contestation happens instead, or is there going to be, for example, a refugee applies for a permit, he's rejected outright, and then is he or she supposed to go and contest it on his own? And with the high costs associated with going to court, is that something that is practical or feasible? Yeah.
Thank you. Maybe we can take, yes, we can take all the questions and then we answer because we are out of time. Yes.
Okay, personally, based on what I've experienced in the camp, I'm a refugee from Kakuma. I'm here at Kenyatta University studying. So sometimes you get to find that you have qualifications the same way as Kenyan have, and you get the same job, but now the payment is even, let's say your payment can double. Like the payment of Kenyan is five times as yours. So let's say, for example, a teacher is paid 40,000 Kenyan shilling, and another teacher who has qualification but is a refugee is paid 6,700 shilling. So are those privileges coming with this program or what, in terms of finance?
Thank you.
Okay, thank you very much. I want to say that I am happy for the development so far. Taking stock of what has been achieved, I wanted to note the following. The de jure position is that laws have been passed, and the developments, the de facto position is that there's very little development that is actually going on. In terms of that, terms of taking stock of what has been achieved, I want to know, have we been able to identify the gaps so that there is a way that the stakeholders in that sector can be able to collaborate to achieve some progress? Thank you.
Any further questions before we?
Okay, thank you for
That is the
this
last
opportunity.
question. Thank you.
Yeah, mine was an explanation maybe or an insight that I would like to request on issue of integration and access to citizenship. I think as per the current constitution, there is a clause that states that for a refugee to gain access to citizenship, he has to have a work permit for more than 15 years, despite being in the country, even let us say for more than 7 years, whereby it accords him to be accepted as a Kenyan through naturalization. So I would like to know, for you to have access to citizenship, is it a must for you to have a work permit for more than 15 years? Thank you.
Okay, thank you. If I get all these questions right, the first question is about litigating these refugee rights, and especially regarding access to services at individual level, and litigating rights as for all. And Benjamin, maybe the second question, I'm going to take it because it is so specific to experience, and I've witnessed it is about the unfair discrimination when it comes to wage payment and salary. So maybe you can give your reflection on the litigation aspect of, maybe I can conclude later. Thank you.
No, Rebecca, and I will leave you that. I think it's best to sort of speak to the lived experiences. I will look at the last question in terms of collaborations in the very same light as the question that was posed in terms of strategic litigation and when we then get to enjoy these rights. Perhaps one of the first things that I will say is that the implementation of this particular act is one that will require all stakeholders to be involved in it. And I know at the center what we're doing is working with institutions like JICA, which is the Judicial Institute for Africa, the East African Law Society, sort of capacity